Joining me now via Skype, host, Long Crime Network, criminal defense attorney Bob Bianchi. Bob, does the history of this case really do him in that there was a complaint, same dogs, a year ago? Is that what leads to the second-degree murder charge?
Yeah, well, Mike, in cases like this, the question becomes whether or not the defendant knew or had a reason to know or should have known that these animals had a violent propensity, and that by leaving them alone, unprotected and able to get outside of that fenced-in area, that they represented a danger to other people, which obviously this tragic case represents. So the answer to your question directly is yes. Any previous involvement that shows violence with respect to these dogs heightens the owner's responsibility to ensure that these dogs are within their sight and within their control so that they can't do something as horrible as what occurred here.
Give us the definition, second-degree murder, and how it applies.
Well, this is not where they're saying it's intentional or that it was premeditated. What they're saying is that there was a course of conduct where it was reasonably likely a conscious disregard to a known risk, and as a result of that conscious disregard, a death resulted as a result of that. So it's not whereas they're saying that he actually pointed a gun at somebody, that he wanted to actually kill the person. That would be the highest level of murder. This is something that's a little bit lower, but still carries significant jail time.
Got it. How about the bail, $2 million? Fair or excessive?
You know, Mike, I'm sorry. You know, as a former head of an agency, as a prosecutor, as a criminal defense lawyer now, a $2 million bail is outrageous. The purpose of bail is to secure the presence of the defendant at trial. It's clear to me, I agree with the defense lawyer here, that the judge was catering to the court of public opinion, and because obviously it's a tragic scenario, but that's no reason to jack a bail up that high. That to me is ludicrous.
Got it. And we heard his defense attorney say, well, he didn't mean for this to happen. I mean, is that the basis for a defense? What is he going to say?
It's a basis for a defense to some charges, but not those reckless charges, Mike, right? So recklessness is an area where some states call it manslaughter, some call it second-degree murder, where, again, you're having a substantially unjustifiable, conscious disregarded risk to the safety of another person. So even though you didn't intend that result to happen, even though you didn't want that poor 9-year-old girl to happen, you knew or should have known, based upon the violent propensity of the dog, that this was a possibility that it could happen, and that's what makes it a crime. So the intention of a person isn't the end of the story from the criminal justice point of view.
Got it. Bob, as always, thanks so much.
You got it, Mike.